A question that often comes up when someone is dealing with a will is this: can a beneficiary also be an executor? And it's a very reasonable question, because on the face of it, it can seem like there might be a conflict. So in this video, I'm going to explain how this works in England and Wales, what the legal position is, and what executors need to be aware of in practice. And if you're currently dealing with probate, I share clear, practical guidance on this channel, so feel free to subscribe if that would be helpful. The short answer is yes, a beneficiary can also be an executor. In fact, it's very common. Many wills appoint close family members, such as a spouse or children, as both executors and beneficiaries. So this is not unusual, and it is legally allowed. The reason this works is because the executor is chosen by the person who made the will. They are selecting someone they trust to carry out their wishes, and often that trusted person is also someone who will benefit from the estate, so the law allows this overlap. However, this is where the key point comes in. Even if you are a beneficiary, when you act as an executor, you have a legal duty to act in the best interests of the estate as a whole. That means acting fairly, being impartial, and not favoring yourself over other beneficiaries. So although you may benefit from the estate, your role as executor comes with responsibilities. In practice, most situations are straightforward, but issues can arise if decisions appear to favor one beneficiary over another, there is disagreement between family members, or there is a lack of transparency. Even if the executor is acting properly, perception can be important, so clear communication is often key. For example, imagine an executor who is also one of several beneficiaries. If they are responsible for selling a property, they must ensure it is sold at a fair market value. They cannot sell it at a reduced price to someone they know or to themselves on favorable terms. That would be a breach of their duties. The best way to manage this is through good practice. That includes keeping clear records, communicating openly with other beneficiaries, and making decisions based on evidence, such as valuations. This helps avoid misunderstandings and protects the executor. There can be situations where conflicts arise. For example, if an executor wants to buy a property from the estate, or if there are disagreements about how assets should be handled. In those cases, additional care is needed, and sometimes professional advice can help. But overall, it's worth emphasizing that this arrangement is very common, and in most cases it works perfectly well. The key is understanding the difference between your role as executor and your position as a beneficiary. So the key takeaway is this: yes, a beneficiary can also be an executor. But when acting as executor, your legal duties come first, and you must act fairly and in the best interests of the estate. If you're acting as an executor, having a clear structure can make everything much easier. So I've put together a free executor's checklist that walks you through the process step by step. You can download it using the link in the description. And if you'd like clear, practical guidance on probate in England and Wales, feel free to subscribe. I'll continue to break these topics down in a straightforward way.